trademark, which is essentially trademark, and then finally invention patent, which is basically your right to your invention that you have created. Well, I won't go too deep into what trademarks are, but basically if you want to know what a trademark is, think of a brand name such as Jollibee, McDonald's, or even Mang Inasal. Those words are trademarked by the company. And trademarking it ensures that no one else can actually use their name in order to actually sell or promote a product without the company's at least permission to do so. So here, in the next portion, we see the validity period. As you can see, while copyright can actually grant you rights over your work, copyright is not permanent. As you can see, there's an expiration date for your copyrighted piece of work. Now, why is there expiration for copyright if copyright enables me to protect my work from fraudulent selling or copying? Well, we'll learn that later on in this particular lesson. But in short, it's actually a good thing that copyright has limits because of something called public domain. If you want to know what's public domain, please stay on the lesson so that we'll actually be able to tackle it. So first, for literary works, during the lifetime of the author plus 50 years after the death, meaning if a particular book such as the Hunger Games was published, the book Hunger Games is basically copyrighted by the author so long as they are alive. Then after their death, it will still be copyrighted for an additional 50 years after the author's death. So this can be a very long time depending on how long the author lives. And the author lives to be as long as 100. It could mean that their work could be copyrighted for 150 years. Now for art, it's clearly much less compared to literary works. Here, 25 years from the date of creation. So this is different from the lifetime of the author. Date of creation means from the date that particular piece of artwork or image has been made to 25 years from now, the copyright for that will expire. So even if the author is alive, if the artist or the author of that particular piece of art has already had has made that art for over 25 years ago, that particular art's copyright will already have expired, and so allowing anyone to be able to use it freely. Next is photographic and audiovisual work as well as sound recording. 50 years since the date of creation of that particular work, in the case of sound recording, when the recording took place. Then broadcast recording, which is 20 years from the date of broadcast. Then trademark, which is valid for 10 years and may be renewed for periods of 10 years. So this means that every 10 years, Jollibee, Mang Inasal, McDonald's, etc. have to essentially renew their trademarks over their names so that they can actually keep using and protect it from unauthorized usage. So they have to keep doing that and renew it every 10 years. Finally, invention patent, which is valid for 20 years from the filing date application, meaning 20 years after the first day that you filed an application for your patent. That means if I were to make a great invention this year in 2021, it will be protected by this invention patent for another 20 years. So by the year 2042, the copyrighted that work would have, my invention would have already been off patent, and anyone now can start using it. Okay, before continuing, I'll have another video play. This one is tackling what the concept of public domain that I earlier mentioned. This is actually rather important so that you'll understand why, on the contrary, even though copyright is very useful in protecting the rights of the author or the creator of that particular work, there's still a need for that right to also have an expiration date. In this video, this will teach you why it's important. So, I'll be playing the clip shortly.
What is the public domain? Why does it matter to you? The public domain is not a place. It's a concept that refers to everything not protected by copyright in the United States. It includes works that were never protected by copyright, as well as those whose term of protection has expired. If it's in the public domain, it's free to use. The existence of the public domain means that there is an extensive and growing cultural legacy, which is available to everyone as a resource for study, development, and material for new creative works. Let's explore how works become a part of the public domain. First, material that is not covered by copyright is in the public domain from the time it is created. For example, facts and ideas are not protected by copyright law and are therefore in the public domain. But note that some things that are not protected by copyright could be covered by other legal protections, such as patent or trademark laws. Second, a work can enter the public domain if it was protected by copyright law and the amount of time it was protected for has expired. Under the Constitution, copyright protection has a limited time. The Founding Fathers gave Congress the power to promote the progress of science by securing for a limited time to authors the exclusive right to writings. Copyright law has changed over time, so when and how a work expires changed too. Under current law, copyright protection covers an original and creative work as soon as it is fixed in a tangible medium, even if the owner has not registered the copyright. The term of copyright protection is the length of time that a work is protected. The term has changed several times over the years. The Copyright Office has a number of resources that discuss copyright terms and requirements, including our circulars. These resources can help you determine if a work is in the public domain. You can research copyright records on-site and at copyright.gov. But you do have to be careful before using material you think is in the public domain. The basis for a work could be material that is in the public domain, but someone else could have made new contributions to that material that may be protected by copyright. Take Romeo and Juliet. Shakespeare's original play is in the public domain. There are lots of movies, books, and updated plays that people have created based on Shakespeare's original work, to which they have added their own original elements that are copyright protected. The new creative expression in these works may be protected by copyright. So, when seeking inspiration from a work in the public domain, go back to the original source. Materials in the public domain can be found all over. Libraries, museums, and archives are great resources. For more information about the public domain and the U.S. Copyright Office, visit copyright.gov.
Okay, so public domain. According to Merriam-Webster Dictionary, public domain is the realm embracing property rights that belong to the community at large, are unprotected by copyright or patent, and are subject to appropriation by anyone. So it's important here to note is the fact that it is subject to appropriation by anyone, meaning anyone can act once a piece of work has been in public domain as a result of the piece of work's copyright expiring. Anyone, me, you, Ma'am Lazon, can now actually begin using that piece of public domain work in whatever way they see fit. This is because it becomes the property of no longer the individual in this case, but becomes the property of the entire community. So here are some examples of public domain works. Myths, legends, folktales. So any of the Philippine myths that you've heard, legends and folktales, especially mga kwentong matatanda, those in particular are already in public domain. Next is the classic works of Sherlock Holmes, Frankenstein, and Romeo and Juliet. These particular pieces of literary work that you've already known for a long time, especially in movies, these are all already in the public domain. Meaning that anyone, any filmmaker, any writer can include these characters or write the story or even sell it if they want to, simply because these particular stories and figures are already in public domain. And finally, classical music like Mozart. So you can actually, so if I were to say want to make a video and has Mozart composition on it, I don't have to worry about that music actually I don't have to worry about getting into trouble with the rights holder of Mozart, because one, Mozart's already in public domain, so anyone can now use it freely, and two, Mozart composed this hundreds of years ago, so I don't think he actually even would bother if someone were to use his work hundreds of years from now. Okay, moving on. Oh yeah, by the way, it's thanks to the fact that Sherlock Holmes, Frankenstein, Romeo and Juliet are in public domain. That's why you can get to see a bunch of movies and animation such as Moriarty and the Patriot and Romeo x Juliet, which are two particular anime I've heard of about concerning these particular characters. So, in review, I would like you to actually answer these questions once again. First, what is copyright? Second, what rights does it give to the author? And third, what is public domain? As usual, I would like you to write your answers on a yellow sheet of pad paper, or you can send it to me directly via Messenger. Either way, I will actually be expecting it shortly. But no need to rush right now, as I wish for you to actually focus entirely on my lesson. Before continuing, I'll give you some time to actually copy what's on screen. You may pause the video so that you'll be able to copy it. Okay, and moving on. Okay, here's some homework, a bonus. Now, this particular bonus, this is actually entirely optional. There won't be deductions on your grade if you don't do this bonus. However, there are bonus points, that's why it's called a bonus, if you actually were to do this particular homework, okay? So you'll get more points. There's no downside if you don't do this, but you have every upside if you do this. So in a yellow bond paper, write a story summary of a piece of classical work found in public domain. So like the examples I mentioned, like Sherlock Holmes, Romeo and Juliet, Frankenstein, Dracula, those particular pieces of work that are found in public domain, I would wish for you to actually write a story summary of those particular classical pieces of literature. There's a lot of classical pieces of literature. If you're wondering, just a quick Google search will actually show considerable list. My advice for you is to try not to actually pick the first top answers or results when it comes to classical works, because otherwise, if all of you start picking the top results, you'll all start repeating the same stories. So as much as possible, I would at least encourage that you try to at least explore those lists of public domain stories and see if there's any story you didn't hear. Then afterwards, research it, write down the summary on the yellow bond paper. Thank you.